All right, folks, we are live. I really want to tell everybody, appreciate everybody jumping in here and joining us this Friday. I think this will be probably the most informative and practical YouTube session that we have done. And I'm going to introduce Jim in here in just a second. As we have people on here, as you're jumping on, definitely let us know that you're on. Say hello. We can say hello back. Richie? Hey, man. Thanks, Richie. I appreciate that. Let's see. Ed, it's good to see you, Ed. Yeah, man. Us too. We are looking forward to that as well. Willie, good to see you. Jason, yeehaw back, buddy. Yeehaw back. Of course, we got Dan on here. All right. Again, folks, as you're joining us, and even for those of you folks that are watching this long after this is done, again, we're going to get into essentially the importance of gun trusts, and we'll let a few more people jump on here. Speaking of lawyers, Bill, how's it going, buddy? Yeah, man, I really, that was the first long-range course that I have ever missed, and really regretted missing that. So hopefully I'll see you at level 2, Bill. I think you're already signed up for level 2 long-range. Steve, good to see you, buddy. Got a few more people jumping on here. Again, folks, I'm here in Guadalajara. I'm actually on the top floor here where the pool is. And this place is, this JW Marriott that I'm staying in, it's a brand new hotel, and it's pretty much empty. But so we got the whole place to ourselves. If the party breaks out behind us, there's a bar back there. If anybody wants a drink, I'll get it for them. We'll see what happens with that. All right. So first of all, folks, I just want to let you know how I came across Jim. GunTrustGuru.com, which I'm going to throw up his banner down here. Any information that you really need to know after this live stream, go to GunTrustGuru.com. It is literally the most simple point and click. There's some basic questions that it's going to ask you, and I will let Jim get into some of the details on that a little bit later. But what you end up with is a gun trust that is state specific. And Jim, if I say anything incorrect, cut me off and let me know, which is actually very important. And again, I'll let Jim get into that. But real quick, Jim, why don't you go ahead and introduce yourself and start off at the beginning, wherever you want to start. Tell us a little about you, why you started creating these gun trusts, and then we'll just kind of take it from there.
Okay, well, I'm Jim Willi. I'm an attorney in Austin, Texas, and I've been doing gun trusts since around 2011. The reason I got into the gun trust world was because I bought my first 2 silencers in my own name because I didn't know what I was doing, just like everybody else. And when I got them home and I saw my name on the tax stamp showing I'm the owner of these silencers, that's when it dawned on me for the first time that I'm the only person in the world who could ever legally be in possession of these silencers till the day I die. And so when I explained that to my wife, who's also an attorney, that, gee, I've got these 2 silencers here and I've got to keep them locked up where you have no access whatsoever for the rest of my life. Otherwise, you're committing a felony. She was pissed off about that and put me on this project to see if there was any other way to buy them. And that's when I dove into that and saw and discovered that you could buy them using an entity. And then when I looked into the entity part, I was thinking, well, this is easy because I can set up entities all day long. But people were talking about something called a trust or a gun trust. And so when I went to the next time I went to the dealer and asked him what's a gun trust, he handed me this Quicken Willmaker form and said, this is what everybody's using. And I was kind of shocked about that, gee, this doesn't look like anything, that not very watertight. Are you sure this is what everybody's using? Oh, yeah, that's what everybody's doing. So anyway, I do estate planning, and so I drew up my own gun trust after looking at what everybody else was doing. And so I've been doing gun trusts ever since.
And Jim, look, just kind of set the conversation off correctly. You know, what does a gun trust do for you essentially, and what does it maybe not do that maybe people think it does.
Okay, well, the two ways of buying them, you can either buy them as an individual or an entity, and I'm just stay on trust because I like that the best of the choice of entities, trust. If you buy it using in your own name, you're the only one who can ever use it. If you buy it using a trust, then anybody you decide to make a trustee anytime during your lifetime, they can use it and possess it just like you can. That's cool because then I could make my wife a trustee, my adult son's trustees, my brother a trustee, and they can use it and possess it just like I can. So that really expanded the ability to be able to let other people borrow NFA things just as easily as I can lend out a regular firearm, at least in Texas. So I was able to almost get to the same point where I can lend out NFA items just like regular firearms. And then the other big thing that's overlooked by almost everybody out there doing gun trusts is that essentially a gun trust is an estate planning document, a revocable living trust. And the main point of a revocable living trust in estate planning is to avoid probate. So if you buy it in your own name, then when you die, it's in your estate, and then you have to probate the will to try to figure out how to get this silencer out of the estate. And it costs, you have to hire, at least in Texas, you have to hire a probate attorney because they want you to probate wills by yourself. So there's about $4,000 to $5,000 right there. You have to wait several months before the judge will finally let you get in the door and appoint somebody as an executor. And then after you get the executor appointed, now they finally have authority to be in possession of it, of the silencer that's been sitting there for 2 months. Now we finally have somebody who can have authority to be in possession. And then they've got this very archaic process of trying to figure out how to transfer it out of the estate. And you have all this proof you have to show to the ATF to get that done. If you buy it using a trust, when you die, the property in the trust passes to the beneficiaries outside probate, no expense, and then you figure out what to do next. But you've already skipped a lot of that process that's involved when you buy it as an individual.
Now, is there a possibility? I've heard this mentioned before. Like, so if you don't have a suppressor or another class 3 item in a trust, is it possible or likely that the ATF is going to seize that item?
So that's a big internet myth. The ATF isn't seizing anything.
Okay.
It's just that you've got this. You've got it. Let's say it's a $500 silencer.
Sure.
That's in the old man's name, and he just died, and the widow's the executor of the will, and she's also, let's say, the beneficiary of the will. But I had that call today. Okay, so how do we transfer it out of the estate? Well, you could hire us to probate your will, so that's going to be $5,000. And then after we finally get the authority from the court to be able to act on behalf, or for you to act on behalf of the estate, now you have this ATF application you've got to pay for and apply and provide all this material to the ATF. Then you have to wait for about 6 to 9 months for the ATF to approve it, and then they finally mail you back the the new tax stamp showing you're the owner. And so the old lady's going, I'm spending how much to get a $500 suppressor? It's cheaper to call the ATF and come pick it up.
Gotcha. So, yeah. So while that process is going on, being that if you don't have a trust and that suppressor cannot be accessible to anyone that doesn't have permission to get to that suppressor, where is that suppressor sitting? Is it just sitting in the safe?
Technically, the executor of the will is the only one who can legally be in possession of it until it's out of the estate.
Okay.
And so even though you don't get appointed as an executor until the court says that's a valid will and you're the executor, there is that time gap where it is kind of questionable that where the ATF really isn't enforcing that, and they're just taking the word for it that the will says she's the executor, so that's perfectly fine. So they're
That makes
not
sense.
cracking down on that. I guess they could if they wanted to, but they're not doing that. But
Sure.
it does leave me uncomfortable that until a will is a worthless piece of paper until a judge says it's valid and appoints an executor. So there is that little gap there that bothers me. But once the executor gets it, then they're at the same starting point of where they would have been if they had just put it in a trust on the front end.
Sure. And
So
it would have cost them a lot less money.
a hell of a mess.
So obviously you can have basically a trust where you're going to have trust, but you can also do this trust, a single trust, correct, for every individual item. Is that my?
I think that's a stupid idea, and I know
Well,
there's a
that's where I
guy.
was going with it.
I know there's a guy that sells those trusts where he's trying to convince everybody one per item. I think that's the stupidest thing I've ever heard of. Number one, if you want to make any kind of amendments, you have to amend how many trusts.
Right.
And want to change your beneficiaries. You got a divorce, you're going to change that. And then most of those trusts really don't have most of the provisions that you would expect to see in just about any trust anywhere. They don't have provisions in there like, every trust has beneficiaries. They don't even go to the trouble of having you ask who inherits when you die. And so those trusts that you're talking about, you have no idea who is going to inherit them when you die. That's not.
Yeah. And folks, I already see some questions popping up over here. I will, we'll definitely throw them up. Continue to send those questions as we're talking along. I definitely want to, I mean, that's what all of our live streams are for, right? Making sure that you guys have the interaction with us or whoever that we have on as a special guest. So again, continue to throw those questions up there. Steve, yes, we will definitely talk about those. I'll throw Jim some questions on that. I have questions on that as well. What I don't want to do is put Jim on the spot for giving, basically free legal advice. We'll definitely get in some of the kind of overarching stuff, but when we get to some specific stuff, again, I'm going to let Jim take full, again, we may get into some specific stuff that you probably need to give him a call on and work out a payment plan or something. Benny Ballista, is a trust required for all NFA items? I'll let you handle that, Jim.
Is the question, is a trust required for NFA items?
Yes.
Not at all. Because like I was talking about, you can buy them as an individual, which is the way that everybody historically has been doing it up to until the 90s and early 2000s. You can buy them as an individual. But you're locked into the fact that it's illegal for your wife be in possession of it when you're at work every day. Your adult children can't be in possession because that's a felony. But you can buy them as an individual. I just think it's a terrible idea.
Sure. Here's a great question right here. Richie Futtrell says, isn't the purpose of a Form 5 for inheritance?
A Form 5 for inheritance?
Yeah.
Yes. When you have a form, when you have a silencer NFA item that's in an estate, then the purpose of the Form 5 is to permit you to transfer a transfer caused by death. And so that's a Form 5 is technically a free transfer. The problem with that free transfer idea is it's not free at all, because you cannot transfer a state-owned NFA item unless you probate the will. And so in Texas, there's no self-probate, and you have to hire an attorney to probate the will. So that's $4,000 to $5,000 right there for an uncontested probate. And then, so you've hired an attorney, you've waited 2 months or so for the judge to declare that to be a valid will and appointing somebody as an executor. Now we've finally got somebody with authority to fill out the Form 5 application. So we've already dropped 4,000 to 5,000 right there. Now you've got to find somebody that can fill out a Form 5 application. So the probate attorneys are going to kick this over to some associate in their firm who's going to charge you, $350 an hour to learn how to fill out Form 5 applications. And then once you get that application filed, yes, you don't pay the $200 transfer tax. But look at all the money you've spent getting that free transfer.
Sure. Gene has a great question. For those of us that live in California where we can't own a suppressor, is there any advantage of having a trust for my modest collection of firearms, all of which are legally owned in California?
The only advantage to having one in California would be simply for probate avoidance. So let's say you have your regular firearms, you put them into the gun trust. Then when you die, instead of those guns passing to the beneficiaries through probate and having accounting in the public records that my beneficiaries inherited $100,000 worth of firearms, and here's the identity of all these beneficiaries. If it's in a trust, those guns are passing quickly, more privately, faster to the beneficiaries without anybody even really knowing about it. So it's more. That's why it's a more sophisticated way to pass a firearms collection to beneficiaries is through a trust.
So it's almost like an addendum and more specified will, if you will. That should just help streamline that process overall, right?
Yeah, because that's the whole purpose of a trust in estate planning, is to pass beneficiaries the properties in the trust that are specifically identified, the property in the trust outside the probate court system, so there's no court control and no public records going to the courts for the whole world to see.
That makes sense. I'll get to your question here in just a second, Ed, but one thing, folks, that a lot of these questions, or at least even like this question, for instance, if you go to his website too, there are definitely some answers to a lot of this stuff. And I'll let Jim speak to this, but what I do like, because I've personally experienced this, is that the format of his gun trust allows you to easily add, remove beneficiaries, people that are trustees, as well as, and again, you can have beneficiaries and trustees, which all his information lays out pretty plainly, even for somebody like me to understand. But it also makes it very easy to add additional items to that. So Ed says, can a newly purchased item be added to an existing trust that was established about 10 years ago?
Can a newly purchased NFA item?
I'm assuming that's what he's talking about.
Be added to a trust?
Yes.
Yes. When you go to the dealer to buy your new NFA item, the dealer's filling out something called an ATF Form 4 application. And what they're doing is they're asking for permission to transfer that one specific make, model, and serial number of thing from the dealer to the trust. So the ATF just needs proof the trust exists. And that's why you're giving the dealer a copy of the gun trust, so they can upload a copy of the trust to the ATF when they're filing the Form 4 application. So it could be, just because it's 10 years old, that doesn't matter. However, back in 2016, they started requiring fingerprints and photographs and FBI background checks on every trustee. And so their term is responsible person, but I tell everybody, at least with my trust, all that they're really asking is how many trustees do you have today, and how many, and you have to get fingerprints, photographs, FBI background checks. So it's possible that a 10-year-old trust is probably not the appropriate vehicle for that unless you rewrite it, which is called amending and restating. Rewrite it and convert it into a more modern format that's more flexible for buying in this new era where they've got fingerprints and photographs and background checks. So you might want to just take a look at maybe updating that trust.
Now, and as I understand it too, tell me if I'm wrong, Jim, but you can basically add and remove trustees at pretty much any point. Is that correct?
So trustees in a gun trust are the authorized users.
Right.
And those are the unsupervised people. And what I mean by that is when I take my friends and my kids to the range, as long as I'm standing right there in the general area supervising, they can shoot them all they want. The
Right.
rule of thumb is you can't let it leave your sight. But if you want to be able to lend it to somebody so they can take it out to the range or ranch without you and use it unsupervised, you have to make them a trustee first. And so if you ever want to make somebody a trustee using our documents, I give you the forms called appointment of additional co-trustee, the other one called removal of additional co-trustee. That gives you the ability to add or remove authorized users called trustees in the future whenever you feel like it without having to come back to us. And then on the appointment form, it gives you a neat little option, or at least mine. It gives you the option of making somebody either a long-term trustee with no termination date, like your wife, for example, who's always has access, or you can make somebody a trustee for a time period like a weekend while they're borrowing your stuff, or you're going on a hunting trip with somebody and don't have to worry about whether they got too far away from you to be legal with your stuff. Make them a trustee for the weekend, they don't have to worry about it. And then when the trip is over, it automatically terminates, it goes in the trash.
Sure.
Never happened, no paper trail. And then the removal form is because you appoint somebody long-term and change your mind. But the specific answer is you can remove trustees anytime you feel like it. You can add trustees anytime you feel like it, except when you have a pending application. And there's a reason for that.
Sure.
You haven't asked.
Well, let me throw a hypothetical out there. Let's say I got 6 people on my trust, but I don't want to get 6, and I would never do this, but let's say I don't want to get 6 fingerprints. Can I remove them off that trust, acquire that device, go through all the process, finally get it, and then I can add, if I add those people back, are they required to get fingerprints and all the other paperwork they're required to do to now be put on that trust for items that have been previously purchased?
You don't have to do any of that stuff.
Okay.
All right. So here's the way I do my thinking on when this whole fingerprinting and photographing requirement came into play. I was reading that about that change of regulations many times, and but the way I set up my trust is you're like if you were setting one up, you're the sole settler of the trust. That means you're the creator, the owner of everything in there. So it's your trust, your guns. Not somebody else's trust, not somebody else's guns. Then you're also the initial trustee. So just on day one, you're the only trustee. That way you're the only one that has to sign the documents to create your trust. Now you're ready to go to the dealer to go buy your first silencer. Because you're the only trustee of the trust when you're at the dealer buying the silencer, then by definition, you're the only one that has to submit fingerprints, photographs, undergo FBI background check, because you're the only responsible person, trustee. And so application goes out, ATF runs the background check, and after about 3 to 6 months, they approve the application. The ATF emails the approval document, everybody calls the tax stamp, to the dealer. And then when the dealer gets the tax stamp, that's the permission slip to conduct the transfer, and that's all it is to a dealer. That's when the dealer calls you and says, hey, the tax stamp's in, come pick up your silencer. You go to the dealer, you fill out the same form you always fill out when you buy a gun from a dealer. That's how a dealer gets a gun off their books. Then they hand you the silencer and the tax stamp, walk out the door. When you come home with your first silencer, that's the first time it ever became relevant whether anybody else was a trustee of that trust, because you didn't have anything in that trust until that day. There wasn't anything to share. Now that you have it home, though, you can appoint trustees, as many as you want, using the appointment form that, both you and the other person have to sign. As soon as you and the other person sign it, and they're a trustee on the spot, so by definition, that means they can use it and possess it just like you can, perfectly legal. And the magic is they didn't have to, get fingerprinted and photographed and undergo any kind of FBI background check whatsoever.
Right.
And so I get a lot of pushback on that. How can that possibly be? That doesn't sound right. I get, my dealer said, well, it's simple. They weren't trustees when you filled out the form at the dealer.
Right.
because when you were at the dealer that day, they were asking you to certify under penalty of perjury how many trustees you have in your gun trust today. And what they were not asking you to certify under penalty of perjury is how many trustees are you going to have on your gun trust someday in the future? Well, hell, I don't know. My grandchildren aren't even born yet. Okay. So always use the wife as the example. You went home with your first silencer, you made your wife a trustee, and now it's perfectly legal for her to be in possession just like you, right?
Right.
Well, everything's going great up until the day you find yourself back over at the dealer buying another silencer. Because now you're at the dealer that day, and it's Paramount Tactical Solutions by that way. You're at the dealer, they're filling out the paperwork, and they get to the part about number of responsible persons. What's two now? Because you made your wife trustee, not me, right?
Right.
So now you call your wife and telling yourself that, hey, I stopped over here at Paramount on the way home from work today, and I'm buying a silencer, and this guy's telling me he's not going to buy this silencer. I should get over here, get fingerprinted, photographed, and make sure he knows I've got your permission to buy this silencer, because he's telling me I'm not able to buy anything anymore NFA without your permission, because I made you a trustee in my trust.
Yeah.
See the problem?
That just sounds un-American.
What do you do if your wife says, no, what the hell are you doing over at Paramount? You're supposed to be making me dinner tonight. Get your ass out of there.
So
remove her.
If I don't want to have to get my wife's permission, I can ostensibly remove her from that trust, go buy my thing.
Go buy it.
Come back. And now, with that being said,
when can you have her back?
Exactly. While that's happening, though, those people cannot have access to those other items.
That's right. Yeah. But the whole point of the appointment and removal forms for trustees is something I came up with when this whole Obama executive order was coming into play. What I was doing there is I was trying to figure out a way to make it a lot easier for me personally to be able to let other people borrow my NFA things. The other thing I was doing, I was trying to make sure nobody could ever prevent you from buying your next NFA item just because they won't cooperate with you.
Right.
And that's the big problem that people are having with their gun trusts all over the country. Mm-hmm. And so that's why I do it this way. And when I came up with this, it was radical. Gun Trust Guru was kind of like the first one that I'm aware of where this idea was out there for the whole world to see, that I came up with this neat way of being able to change the number of responsible persons, to be whatever number I need it to be on any given day. But the other rule, when can you add her back? So the rule here is you cannot add trustees while there's a pending application, because they don't like you to change the answer on them while there's a pending application. Sure. So I tell everybody, wait until you bring that new silencer home, and then you can go back to adding all you want, and nobody cares, and the ATF doesn't even want to hear about it. Right. Because there's nothing to do with the ATF. They have no pending application they're attempting to make a decision about. So
I know before I understood that you could add and remove, we ran into the same issue where I had a couple of people on as trustees, and it was holding up the process because they wouldn't go and get their fingerprints done. Even if we were like, look, man, I'll pay for your fingerprints. Just take the 5 minutes and stop. And this was back before electronic form and all that stuff. So that is a very nice.
And that's why I rewrite a whole lot of people's trusts. Amend and restate is what that's called. Old gun trusts, and amend and restate them, rewrite them, so that I can get rid of all those trustees that are hard written into the documents. That way the husband can go buy a silencer. He doesn't have to ask for anybody's permission.
Makes perfect sense. Yeah. Then Ballistics says, what would happen if your beneficiary lives in a NFA restricted state? Does the NFA trust still allow them to have those items?
So the real question is, it's a kind of black and white. Something either is or is not legal to be in possession of, regardless of whether it's a person or an entity. So if they live in California, it's illegal to be in possession of a silencer, whether it's, if it's not law enforcement or military, it's illegal. So It doesn't matter the fact that it's held by a trust, but they can't possess it.
They can't
Illinois.
possess it there in California, to be
Yeah,
clear,
but
right?
it can be stored in Arizona
Sure.
or
Sure.
Indiana.
No,
So they can inherit it, but they would just have to store it somewhere else.
makes perfect sense. Once you have the trust, does it have to be filed or recorded anywhere, or just start whatever buying that you want?
A trust is like a will. You go down to the lawyer's office and get a will. Nobody needs to see that. It's not a public document. Same thing with a trust. So the only time, the first time anybody's going to know you've got a trust is when you're at the dealer buying an NFA item, because you have to include a copy of the trust in the Form 4 application. So you're giving the dealer a copy of the trust, and he uploads it to the ATF's website when he's filling out that Form 4 application.
Here's a good question. I never thought about this, to be honest with you. Benny Ballista says, if inheriting a firearm trust, is there capital gains on said items like it would be with property?
No. This is an estate planning question. So when you inherit property under the tax law, there is a step up in basis, and you're not paying any kind of capital gains on property you inherit. The only thing that you have to worry about is perhaps a state tax. But right now, the federal limit on estate tax is somewhere around $12.4 million. So unless your estate's that big, and I hope it is, there's no estate tax.
Does a trustee have to be over 18? What's the law on that, Jim?
Yes, you have to be an adult to sign a contract, and a trust is kind of like a contract. And so, yes, you have to be at least an adult to sign to be a trustee.
Yeah.
18.
So
but you have to be 21 to buy from a dealer.
But again, you do not have to be 21. So, for instance, if I have my 19-year-old son, he can be part of the trust. He didn't go buy the firearm. Just like you have to be 18 to buy a rifle in most areas, but you can still let your kid use the rifle. Is that how I understand
Yeah,
it?
when my son was my shooting buddy's son, I've got some nerdy ones that never go to the range with me. But my shooting buddy's son, when he was 16, 17, when we'd go shoot silencers and everything, I'd have to stay right there with him on the firing line because I'm the trustee and he's just a guest, right? And so I have to be supervising. But as soon as he turned 18, I appointed him as a trustee. Now he's good to go, and I can go walk around the store and go look at, talk to people and look at stuff while he's out on the firing line.
Yeah.
Because you have to be 18 to be a trustee. But I made him one on his 18th birthday.
My wife says, just remember your wife is watching, Gary. So there's that. Some of your wives are probably watching too.
Yeah. My wife doesn't explain trust the same way I do.
Well, just like I tell my wife regularly, men out there, look, sometimes you got to go make a big purchase without permission just to establish your dominance. Just letting you guys know that now. And I only say that because I'm in Guadalajara, far away from my wife. So, so Jim, also, what is your, again, what really, and I don't even remember how I came across your site, but after doing a lot of research and finding the interwebs, doing it about trust in general, the one thing that I loved about your trust format, number one, it was very easy to do. Number two was the fact that it had a lot more specificity in it than almost any other one that I came across. Can you just kind of talk about, if people decide not to buy from you, which folks, go to his website, support him, get a trust from him. Sounds like some of you need some updated trust. But if they decide they're not going to buy from you, what are some things to look to avoid, if you will?
Well, one of the reasons I came up with Gun Trust Guru was actually a specific big, very large, biggest in the country silencer retailer. They were the ones that called me originally and said, we love your law firm trust. We just love it when we get yours as opposed to everybody else's, and makes perfect sense to us. But is there anything you could do that you could create for us so we could have a gun trust that we could sell at the counter that would, so we weren't pushing somebody else's crap that was really prominent at the time? And so I actually looked at what everybody else was doing, and then I came up with this Gun Trust Guru program for that big dealer. And so they've been using it ever since. And it's and they've been they're my number one customer. But while I was at it, I was thinking, well, gee, why not just automate this whole thing, and then while I'm here, put this thing out of the internet for everybody else in the world to use. So that's why I came up with that. But one of the big defects that I see in most of the other trusts is, fundamentally, a trust is like a will. And so fundamentally, every trust has beneficiaries, and that's who inherits when you die. And some of the trusts out there don't even bother asking you who inherits when you die. That ought to be a gigantic red flag, because in estate planning, we basically say, here's our primary beneficiaries, first in line to inherit. Here's secondary beneficiaries, second in line. And if every one of them are dead, then it goes to my heirs. And heirs is a legal term that cannot be defined until you're dead. And then heirs has a specific meaning depending on whether they're single, whether they're married, whether all the kids are from the same wife, or whether it's a blended marriage. Heirs can be any one or all of these people, and there's no way to control who that definition would be until you die. Then you've got to go to court to have somebody figure out, legally, who are the heirs. That's another big expense. And then finally, we've got somebody who can now inherit. Well, why would you do that? Why not just say exactly who you intend to have inherit? Whether it's my 4 sons, or whether it's my wife, then my 4 sons, and list them out by name so that you're not having to go to court to go figure out who just inherited all this stuff. So that's a gigantic red flag, and that's one of the features on a bunch of the trusts that I see out there that we compete against. And then there's another gigantic defect that I see in some of the other trusts that we compete against. There's this one other term, and they think you're not smart enough to understand what it means, and so they just blow it off and don't even include this idea. But there's a term, it's called successor trustee. And the big takeaway is that a successor trustee is not a trustee. A successor trustee is somebody who's replacing you, the settler, someday as trustee because something as bad has happened to you, like you died. And so all it is a contingency position, and it doesn't mean anything at all while you're alive and well, just like the beneficiary section doesn't mean anything while you're alive. And so all it's trying to do is to say something like, someday in the future, if the trust lost all of its trustees, well, then we've got a gigantic problem here because there's nobody allowed to be in possession. And so it says, if that were to ever happen, then you guys have permission to step up and become trustees at that time. And that's all that they're trying to say. But where it kicks in is, I get these calls. Man goes out, gets himself a gun trust. It makes the wife the beneficiary because that trust allowed you to have a beneficiary. And then he goes out and buys a silencer, gets it home, never made anybody else a trustee, and then husband dies of COVID. So the wife just inherited, right? So she's the beneficiary, but she's got a little problem here. Trustees are the only people allowed to be in possession of NFA stuff, period. And so now the wife's trying to figure out how to become a trustee now that the husband's dead. And our document has a successor trustee provision that I'm hoping that wife's name is right there in that successor trustee paragraph. But a lot of those other trusts don't even have that paragraph. And so when the trust does not say what to do, then you have to hire an attorney, go file a brand new lawsuit. go file a new motion in the court. You have to wait for about 2 months before you get to have a hearing. And then finally, you have to get up. The lawyer has to explain to the judge that the husband bought this trust over here. It doesn't have any successor trustee provisions in it. And so the only way to fix it is to have the court sign an order appointing that wife as a trustee.
Hmm.
So how much?
Yeah. So
we do those fairly regularly because of COVID. That's $2,500 right there, just because they didn't put a successor trustee provision in the trust.
right. And you know, I know there's a lot of, I'm sure you come across it all the time. I know I do. There's a lot of myths out there when it comes to class 3 items and trusts and everything else. One of the things that I've heard, and just let me know if this is true, is basically if I have a suppressor in the home and I do not have my wife or kids on that as a trustee, so I'm the sole owner of that said suppressor. Essentially, and I keep that in my safe, essentially, if I'm gone and my wife has access to that safe or knows the combination, that is essentially, she could be considered a felon, or I'm a felon, or tell me how that works.
So I don't know about your state, but in my state, you're required to store firearms so that they're not accessible to minors or to, so the way I like to view it is anybody who's not a trustee of the trust is a 5-year-old. Okay. And including the wife. So they're either are or are not a trustee. And so they're either a 5-year-old or they're not. And so you have to store your firearms safely the way you would store it as if they all these other people in the world, non-trustees, were 5-year-olds. So there doesn't have to be Fort Knox. It just has to be, whatever is a reasonable thing to do it wherever your jurisdiction is. Okay. Now, if you keep them stored in the safe and your wife has the combination of the safe, technically she has access. Okay. Now, I used to be really paranoid about that. And maybe that was a good thing because that's the way I thought about this when I was putting it all together. But I have a firm believer that the ATF is not sitting at the end of the driveway waiting for Gary to get on his plane to Guadalajara, just so they can then knock on the door and ask your wife whether she, it's always bugged us, did Gary ever give you the combination of the gun safe?
Sure.
Because your wife is clearly smart enough to say, no, he never did. And that's always bugged me about Gary.
Yeah.
But so there could never be any good reason for you to say, of course I've got access to the safe.
No, I think ultimately, just like, and again, if most people understand how law enforcement works, it's not necessarily one of those things that are going to come knocking on the door for. But if something were to happen, that'd be another charge to tack on. That's really my concern, where you get hemmed up for God knows what, and then that's just another thing that they're throwing at you, and it's another thing to be aware of, just for this reason, so that you can answer questions correctly.
Yeah.
But what I do know is that law enforcement, and again, folks, I just posted a video where it showed ATF just knocking on people's doors in Delaware, was the specific one that I posted, and saying, hey, I saw that you guys bought a bunch of guns. I need to see those guns that you purchased. So the other part of this is there's laws that are on the books that I won't say necessarily haven't been enforced, but they haven't been aggressive about. And, I think that changes with the political wind. And I think that me personally, and why I thought it was so important to have you on, is that I think we're going to start seeing a much more aggressive ATF and a much more aggressive law enforcement on these matters, because not only do we have corporations and all these other entities that have always been anti-gun, I think we essentially now have a federal government that is fallen in step with that and is now, vehemently anti-gun. And again, I think it also is part of the fact that politically they know that people that are gun owners are not on that side of the spectrum. So it's just another way to suppress and oppress people that are on a different political spectrum as well.
That's why I made it really easy to make somebody a trustee, because it's no big thing for you to just print out an appointment of additional co-trustee form and have you and your wife sign it and you're done. And so I try to make it really easy so that you can make your wife a trustee, so that it's not that big of a deal. We added a new thing in February that was at the request of that big dealer during COVID. The problem was they wanted to know whether you absolutely positively had to have your documents notarized for them to be valid. And I put him off as long as I could, but he kept hammering me that he wanted to do that because back in especially during COVID, it was really hard to get in front of a notary, and people just didn't want to be close to you like that. And so we did all the research to see what states require notaries for trusts and which don't. And so when we had that option of when a state didn't require it to be valid, then we introduced an extra question there that said, do you want to require your documents to be notarized, yes or no? So when you have that option, then you have the option of appointing trustees without having the documents notarized. So that's really cool, because if you and I went down to the ranch in South Texas and we got down there and I went, damn, I forgot to make Gary a trustee. We can't go 30 miles into town to go find a notary on Sunday morning.
Sure.
With no notary option, I can make you a notary, a trustee on the hood of the truck, and then you can walk off with my silencer.
Yeah, so, folks, I know if I remember correctly, that is exactly how it is in West Virginia, and we had checked that option. Folks, it was literally removing somebody was throwing away a piece of paper, and then adding somebody was essentially filling out another piece of paper and printing it out and add it to the rest of the.
Sign it, date it, no notary required. And that's the way it is in Texas, and that's the way I do my law firm documents, is I don't require a notary for adding or removing trustees.
A couple of things, folks. Number one, Alex, hello. A couple other folks that I meant to say hello to that I didn't get a chance to was John Walsh and Mark Lloyd. Thanks for joining us, and everybody else that got some more folks on here. This is a big one, and I can answer this, but you can tell me if I'm wrong on this. Richard says, I remember people complaining about changes to trust 3 or 4 years ago. What changed exactly? As I understood it, ATF changed the rules where the people on a trust originally, I know when I first got my trust, they did not have to be fingerprinted,
sure,
and have those individual background checks.
Right.
They changed. So basically, if you had a trust, you didn't have to do any background check. Nobody on that trust had to do it.
That's right.
And now that has changed to where anyone on that trust does have to have a background check and fingerprints done, correct?
Anybody who can use and possess is a responsible person. And so the way in my trust, that means trustees only, nobody else. A lot of the other trusts out there, they'll have a line in there that says anybody who's a beneficiary can also use and possess. And so that makes them into a trustee technically. And so, but that makes them a responsible person too. So depending on who wrote the trust, it may be trustees only, or it may be trustees and other people. And so when I was doing my trust, I was trying to stay in really rigid classic definitions of this is what it means to be a settler. This is what it means to be a trustee. This is what it means to be a beneficiary. But as part of the sales marketing of my trust is better than your trust kind of thing, a lot of the other guys were out there expanding the definition of trustee without even knowing it to include anybody that ever even thought about your silencers. And so that is why, like beneficiaries, successor trustees, anybody who, if I see you at the range, you're a trustee, but because of that sloppy drafting on a lot of the trusts, then there became this idea out there that, oh my God, if anybody's name appears anywhere on the trust, doesn't matter what they are, they've got to get fingerprint and photograph. That's not true. It's just people who can use and possess, and that's supposed to be trustees only. So I'm always fighting that all the time. Dealers going, wait a minute, if anybody's name shows up anywhere on the trust, it has to be fingerprints and photographs. But if they do it, and the ATF reads it and says, why are you claiming this beneficiary is a responsible person? Because they're not a trustee. Then they reject the application on that basis too. So if you just blindly put fingerprints and photographs of everybody whose name is in the trust, you're just as likely to get a rejection for that basis. Because I try to keep mine to trustees only, nobody else.
Sure.
But the big change that you were mentioned, do you want me to talk about that, or?
Yeah, well, I do. I do want to make a point, and that is, folks, and this is something that Jim and I spent some time talking about before we jumped on here. The fact of the matter is that not all trusts are created equal. And again, just getting into some of these kind of the minutia and the specificity that there again, his trust address is really important. You know, you can pay some money or even get some of these things offline for free, and you're holding a worthless document that isn't going to cover you for a lot of different situations. Whereas you get a guy with Gun Trust Guru, you're getting a guy that specializes in estate planning, that ventured over into this and understands the ins and outs of that. And I think the little bit of money that you're going to spend on the trust is going to be a huge investment, a good investment, but also just the peace of mind knowing that everybody out there is a bar stool lawyer. And as we talked about before we jumped on here, that Jim brought up, a lot of these folks that are selling you trust, they're not lawyers. And take that for
that they've got attorneys on staff.
Absolutely.
What staff? I have a stack of trusts over here on my desk over here, because I'm also having to give a presentation to the state bar, to the attorneys and everything, and they wanted me to specifically talk about all the trusts that I see and all the problems with them. And I'm like, it's going to be, they want me to talk for 30 minutes just on what's wrong with all these other trusts that I see. And so I'm having to go through and mark up provisions of trust. Some are attorneys and some are not, and explain to the lawyers what's wrong with this and why you don't want to do this. And I have one that was a $900 trust that somebody paid for last month from an attorney. And right off the bat, it says that anybody who's a beneficiary can use and possess just like anybody else. And so that means then that everybody who's a beneficiary also has to get fingerprinted, photographed, and undergo FBI background checks. That's crazy. So, but the big change, I guess, that really caused all the problems was, in 2016, they started requiring fingerprints and photographs and FBI background checks of all trustees or anybody can use and possess. Back in the day, back before 2016, let's say, the old way of doing it was you would try to anticipate every single trustee, every person that you thought might ever want to be in possession of any of your NFA stuff, and you'd write them into the documents as trustees. And then to be able to create the trust, then you've got to get signed and notarized signatures of every single trustee, and then you could finally go to the dealer to go buy your first silencer. And then back in the day, the only thing that was needed was a copy of the trust and a $200 tax payment. Application went out, tax stamp came back, guaranteed every single time. Okay. And so I'm telling you that I've been able to buy silencers and short barrel rifles and things like that for years without my wife knowing anything about it, because all they needed was a copy of the trust and $200. They just magically showed up in my gun safe. But Obama fucked me, because back in 2016, they started requiring fingerprints and photographs of every trustee every time you bought something. And my wife was a trustee. And so so that meant that every time I wanted to go out and buy any kind of an NFA item, I had to get her permission. She had to know about it, and she watched the money coming out of the account. And then I would pay hell for that, because she'd go to the mall and buy a new purse and dresses and shoes and all that stuff. By the time I got to the dealer, the money was already gone. So that's why I came up with this new way of doing it, with adding and removing trustees, because I wanted to be able to get rid of trustees, be able to go out and buy something without having to have anybody's permission. And then when I got it home and it magically showed up in my gun safe, then I could add them back as trustees.
Sure. Before we get to Richie's question here, I do want to mention real quick. I know Dan and Some are on here. Dan, make sure he's our web guy. Dan, make sure that we have Jim's contact information, and I mean the guntrustguru.com website on there, and let's throw that on a few different pages with our gun purchasing areas so that we are pushing people to the right people. We have always, as I've told Jim, we've always, when someone asks us about gun trusts, we've always directed them to Jim, but I want to be a little bit more proactive about that and make sure that's on the website, because for every person that does ask us, there's 20 that didn't know to ask us or didn't know any better. And so we'll make sure that we are make sure that we're providing the right information right up front so people start thinking about these ahead of time. Richie says, I see mixed information. Do you have to keep your tax stamp trust with the suppressor when transporting, etc.? Jim, that's all you.
There is no law that says you're required to carry the tax stamp or anything on you. That at least in most jurisdictions that I'm aware of, especially Texas, there is no law that says you have to do that. The problem is that the game warden or police officer that you happen to run into, or gun store employee, they don't know it. And so if you were to get pulled over by a police officer and they, or more likely the game warden, you're out on the ranch and you get the game warden pulls up. First thing they ask you for is a copy of the hunting, let's see your hunting license. You pull it out of your hunting jacket, and then they'll casually ask you, do you have the paperwork on that silencer? And so that's why I like to have a copy of the tax stamp on me so that I can hand it to him, and he hands it back to me about as fast as it took me to hand it to him, because all they want to know is just make sure that's a legal silencer and they're done. But
so it's more of just a conflict avoidance and mitigation than necessarily a legal requirement.
Yeah, and then back before 2015, at least in Texas, the law was weird. They had the burden shifted on burden of proof on NFA items. So back then, the law said we're presuming that you're illegally in possession of an NFA item unless you can prove otherwise. And so
that's constitutional.
So that back then I told everybody, okay, I want to make damn sure you have a copy of the tax stamp, because that's the legal proof that's a legal registered silencer. I want you to have a copy of the trust, so that's that's the same name, that this is the owner, this is the trust. And then I want you to be able to have the proof, the trust proves you're a trustee. And then I want you to have your driver's license, which matches the name of the trust, so that we can say, see, that's me. Here's my picture. That's me. I was wanting everybody to carry proof, that whole chain of proof you need to prove that's a legal registered silencer. In 2015, I actually testified in the Senate committee on this and explained to the committee that this violates the whole way of American law, that innocent until proven guilty. That ought to be the other way around, is that law enforcement's the one, or the state is the one that with the burden of proof on this issue, that's an illegal weapon. So now I've kind of relaxed that idea, that I tell everybody, make sure you've got a copy of your tax stamp on you, just in case they don't know, that you don't have to, that they don't know you don't have to be carrying it, but there's no need for it. But I think it's a great idea just to save you the ride down, where you get arrested and you've got to cough up a tax stamp to prove that's legal. You follow that?
No, 100%. I mean, that makes perfect sense.
So
overall, your legal advice is keep a copy of your tax stamp. Do you feel it's necessary to keep a copy of your trust on you as well?
I don't carry a copy of my trust anymore, but and all of our trusts have our name on there, Willi NFA Trust. If it's a Willi, they're probably going to be perfectly fine. But if it was Gary Melton trustee, and this is owned by the Willi NFA Trust, I'd prefer you to have your tax stamp and a copy of your appointment form so you could prove you're a trustee of my trust.
I see what you're saying.
Okay.
Makes sense.
Yeah.
Derek says, will his company restate a trust created by another company? Or another attorney. That kind of goes in line with a question that I had thought of earlier, the fact that if you already have a trust in place and you decide to create another trust, maybe that trust sucks. Is there any conflicts in his or my question regarding
if you go, the Gun Trust Guru platform is intended to be a do-it-yourself gun trust form generating program. And so when you go to the Let's Get Started page, it gives you the option of creating a brand new trust or amending and restating an existing trust. So rewriting an old trust is amending and restating it. And so when you go into that feature, then it's asking, okay, what's the name of the trust? And it needs to be the same name that's on all your tax stamps, it's on the trust, it's on the tax stamps. And that's going to ask you what date was it created? And then after that, it's just like creating a brand new trust.
Perfect.
Same, very smooth process. And then that's the way you get rid of all your trustees. And that's the way you set your beneficiaries the way you want them to be now. And then successor trustees, I'm a big fan of being the successors are also the beneficiaries of the successor trustee.
Makes sense.
That if you died, those people have the ability to step up, become trustees.
Now, what if I just have what's in my mind just a poorly written trust to begin with, or I just, for whatever reason, is there any major legal action he takes to dissolve that trust? And then if I wanted to, can I just say, you know what, I want these guns to go in this new trust that I created?
Yeah. Well, there's two reasons I see that, two issues going on. I got a trust from I don't know where years ago, and I never did anything with it. Well, that one goes in the trash because there's no NFA items in it. So let's just create a brand new one. But if you do have an NFA item that's in a trust, right, and it's garbage, if you create a new trust, you have to file an ATF Form 4 application and pay a $200 transfer tax to move it from this trust to this trust. So I want you to try to fix the old one first, because when you rewrite it, amend and restate, you're not creating a new trust, you're creating a new document that is the trust. So everything that's in there is still in there, but going forward, you're just using this trust document. And all the provisions of the trust are all contained in this document instead of the old one. So I want you to save money by fixing that other one.
All right, we got Sheriff Nathan Harmon jumping on here. I agree, our officers need more education on this. That is absolute great point. Again, there's lots of good officers out there that are doing their best to, they go to an academy, they go to the training they get, their follow-on training, whatever it is. And the fact of the matter is that officers just can't be expected to be legal experts in every area. And quite frankly, just like expecting a lawyer to be a legal expert in every area, it's impossible. So again, that's another good reason that we want to do things like this, especially, it's complicated, and quite frankly, it's scary, because we're doing everything that we can as gun owners, as responsible gun owners, to do the right thing. And again, we want to be able to help our officers and everybody else out there to get educated. And the way to get educated, folks, hearing it once doesn't make you an expert, right? So what we're doing is we're providing you resources. Just like after this, I'm not an expert in ATF anything. If you come to me with questions, if I don't have clear that I know 100%, I point them to an expert. In the same manner that just because you come to a Paramount course does not make you a firearms instructor. So make sure that you're pointing people to subject matter experts. And again, that's why I love Jim. And the other thing about that, folks, again, you guys don't have the background, but Summer and I have had many questions many times where we've either emailed Jim or called him, or he's called us directly after an email and has been very available. And I just can't tell you how much I appreciate that. And again, go to his website first. Don't call him. He's got 1,000 calls a day. find the information there. If you exhaust that, then maybe you email them or give them a call or something like that. But anyways, just wanted to make that point. Let's see. Does trust help with pre-86 NFA items for the next person getting those items?
Yeah, because it's the same idea that any kind of NFA item can be held in the trust, and so I have a lot of old men that are trying to get rid of their machine guns, and like let's say son, it's time for son to take over. So we're setting up a gun trust for the son, and then we're transferring them from the dad to the son's trust while dad is still alive. And then after the tax stamp comes back, we're making dad a trustee of that trust that's, it's now in the son's trust. That way dad can sit on those guns for the rest of his life as a trustee until he gets too old to be able to be in possession, and then the son can go pick them up. The other thing is, let's say I want to sell a machine gun. Putting it into a trust makes it a whole lot easier to sell them as well. This is kind of slick, but let's say I want to sell a machine gun to one of Gary's customers in West Virginia. Okay. If I have it as an individual, then I've got to transfer it to a Texas dealer on a Form 4, and I've got to pay a $200 transfer tax to get it over the dealer, okay, in Texas. So I've waited about 8 to 12 months for the tax stamp to come back through. Then after the dealer gets the tax stamp and the gun, then they can do a quick Form 3 transfer to the dealer and ship it up to Gary. And then now Gary's customer, Gary has to do a Form 4 application to transfer from Gary Paramount to the West Virginia resident, and that's another 8 to 12 months for that. So transferring a machine gun that's individually owned from me to Gary's customer, that's about a 2-year process. You follow that?
Absolutely.
So the other way to do it, though, is if it's in a trust, it makes it a whole lot easier, because I can do the ATF paperwork I can make somebody a trustee of my trust in West Virginia. After he gives me his money, I make him a trustee. I transfer the physical possession of that machine gun to the guy in West Virginia who just paid for it. And then we can do a Form 4 transfer from my trust at the West Virginia address to Gary's customer who has a trust at his address. And I can do a Form 4 transfer that's basically from my trust to his trust, all using that guy's address. And then when the tax stamp comes back in, it gets mailed back to my trust at West Virginia customer's house, transaction complete. A lot of people don't know you can do that. That's why big fan of putting your machine guns in a trust, because it makes them a lot easier to sell them someday.
No, that's a great question and a great answer. Opinion Ballistics also says, Gary, I didn't mean any disrespect about follow-up PRS rules clarification video. None taken, buddy. There's still, the funny thing is I actually got, obviously we're on another tangent, but I'm still receiving conflicting information on that. So both from people that are tied directly with PRS. Anyways, so neither here nor there. None
conflicting information on what?
So this was a whole nother topic. He was talking about it. Yeah, no. I'm sorry. Anyways, he sent me a video about. We're talking about PRS rules and what it comes down to as far as production class rifles. And he just want to make sure I didn't feel disrespected by him sending a video that clarified that to some extent. Still not sure about that, but it is what it is. Mm-hmm. Hypothetical. You've built a trust designating your son, daughter as a trustee in your passing. But throughout a period of time, they become mentally incompetent, drug, alcohol addicted. What happens with the trust then?
So you've passed guns to, and now the later trustees have also become incompetent as well. There's always a provision in my trust for somebody else to be able to become appointed as a trustee, so that there's at no point are we in a position where we just can't get somebody to be able to be legally in possession of those NFA items.
So yeah, what happens essentially? Let's say I have a bunch of NFA items, and either all my family members are incompetent, or I don't have any family members. What's going to happen to those items at that point?
Well, it's going to go number one, if a beneficiary is incompetent or a prohibited person, or basically a prohibited person is kind of encompasses the criminals and the incompetence and all that kind of stuff. But if a beneficiary is before inheriting becomes one of those prohibited persons, then they're treated as if they died. They predeceased you, and so they're skipped over for inheritance purposes. If they receive them through inheritance and then later become a prohibited person, then there is provision in there for somebody to be appointed as a trustee so they could legally take possession of those guns, so that we can try to prevent anything from being confiscated, because we always try to have somebody who can legally be in possession. And if the kids became incompetent and they had somebody who could legally take possession, they could potentially sell the guns and use it for their medical, or for their benefit.
Gotcha.
So that's a pretty good, thing to be thinking about, is what happens next, what happens next, what happens next.
Absolutely.
Yeah.
Richie says, do you forfeit any of your rights by owning an NFA item? Search and seizure changes based on ownership. So he's kind of go ahead, answer that. Yep.
No, no. This whole NFA thing, it's just a big taxing scheme. The ATF wants their fucking money. They want $200 again and again and again and again and again. This is what funds the ATF.
Right.
This is a taxing scheme. It's economic warfare against the the middle and lower classes, so that people can't afford this kind of stuff. So they're more than happy for you to be buying as many as you can, so they get all this money coming in all the time. You're not giving up any Fourth Amendment rights of search and seizure just because you paid a tax sometime in your life to be able to acquire something. You paid the tax. They could care less that you own this. If they want to search your house, they have to have a search warrant, just like they would for anything else. So this has nothing to do with losing rights just because you decide to pay a $200 transfer tax at some point in your life.
Yeah. So the ATF, just because you have NFA items, they could at no point do they have the legal authority to just come to your house and demand to see them or anything like that.
Absolutely not.
Well,
I mean, about the only people that I guess technically could do it would be the ATF themselves, and the only authority they really have is to knock on the door and say, "Gee, Mr. Willi, we hear you got a lot of NFA things." "Oh yeah, I got a few. Can we see the original tax stamps?" "Okay," and I'll go get them and close the door and leave them out on the porch. And you go get your tax stamps. You come back out, stand on your porch, and they can look at my original tax stamps all day long. They don't get in the house, right. And they don't get to see the guns either.
So they do technically. So you're saying that they do technically have the authority to demand to see
the original tax stamps, okay, so they can see if that's a legal registered item.
Fair enough.
But that's about it, but nobody on the state level does really. They'd have to have a search warrant.
So local law enforcement does not have that authority.
No, because this is ATF just wants to know if there's a original tax stamp, because maybe their records are showing something different, but that's probably not going to happen.
Fair
And
enough.
if I was worried about this, they'd be knocking on my doors already. I've got like an inch thick binder full of tax stamps.
I think I'm pretty sure I'm one of your benefactors. If not, you can make that happen after this. Is there any point?
Mine's small compared to other people's collections. I know.
All you rookies out there, you got to get those numbers up.
Yeah.
Is there any point where in this situation where the county sheriff becomes a conservator due to the lack of anyone being able to take responsibility, ownership, if there's no family members to take ownership?
No. Now we're getting to like estate planning questions, just like that. Like there's nobody around. They're going to keep digging and digging and looking for heirs until they finally come up, find an heir. An heir could be, all the way up to, going up to like a single man. If he dies, it's his parents are his heirs. And if the parents are dead, it's the brothers and sisters. And if they're dead, they go back and look at the grandparents. And if they're all dead, they look at the uncles. And if they're and aunts and uncles, if they're dead, then they go looking for cousins. There's always going to be a family tree somewhere. They're going to have to go find an heir.
Sure.
But if they couldn't, then technically it could be escheated to the state. So, but the likelihood of that happening is extremely low because you've already determined who your beneficiaries are. And then the catch-all phrase is if all these people are dead, it goes to my heirs. You've included a gigantic pool of people.
Sure. Benny Ballistics likes how blunt you are, Jim. Let's see what we got here. Greg,
that was blunt, except that thing about Obama.
Well, I think you're giving a straightforward answer and not the normal legalese a lot of people are used to from lawyers. So I think that's greatly appreciated. I know I do. Greg Scott says 5320.20. I don't know if we're talking in Morse code, computer code, or legal code.
Uh-huh. What about it?
Great question. Greg, why don't you clarify that question for us a little bit there, bud? Derek says, what is the expected out form for a LEO perspective when they receive the Clio copy of the form 4? Is it simply a notification for them and it should be disposed of?
So what is this a Clio asking what am I supposed to do with the Clio form?
Derek, clarify that question. We'll come back to you. All right. Here's Nate Harm. We'll come back to that. But a citizen is not legally obligated to show them anything, including a tax doc or doc pertaining to multiple gun purchases. I saw a video recently where the ATF showed up on the porch asking citizens to show them their guns, purchase orders, etc. Granted, the spirit is the ATF was assuring the person still had the guns and didn't sell them off, but my problem is citizens' rights do not obligate them to actually produce such docs upon demand on the front porch. Basically, Nate, I know what he was saying was the ATF does have the authority to ask you for your tax stamps and to look at your paperwork. They do not have the authority, and that's only the ATF, from what Jim said, not local law enforcement, not any other agencies, to ask to look at your paperwork for your class 3 items. They have no authority to ask for they can ask. You have no obligation to show them anything.
Right.
Did I get that right?
They may think they've got the authority, and that's why I let them see a copy of my tax stamps. The game warden, if he asks for, hey, you have a copy of your tax stamp? Sure, here it is. Okay, and he hands it right back to you. They don't want to. They're not trying to bust you. They just want to make sure everybody's happy. And he's not worried about it. You're not worried about it. So I would show it to him just because I want him to go pick on that guy across the street.
Sure. Does it need to be carried as a form transportation across state lines?
Does it need to be carried a form? So I think what he's trying to say is
220.
do I need to have a 5320.20? I call that an ATF change of address form, because even though it doesn't have that name, it doesn't say change of address, but I call that change of address form. But it's the interstate travel form. Okay. Every kind of NFA firearm except for a silencer, you have to have advance written permission from the ATF to travel across state lines. Okay. So you can go back and forth across state lines from Texas to Virginia all day long. Nobody cares, but if as long as it's a silencer. You can't take silencers to 7 states right now. Hawaii, California, Illinois, and then some of those states up in the Northeast that nobody cares about, you know. But nowhere in the South or in the Midwest except California and Illinois do we even have this problem. So you can go back and forth with silencers all day long. But other kinds of NFA items, like most commonly short barrel rifle, you have to have advance written permission to take them across state lines. So the problem with that is you file an ATF change of address form or interstate travel 5320.20, and you file it, and it takes about 30 days for them to finally get around to approving it. And they mail you the approval back. So it's a slow boat. And then you have to say, here's my travel dates, my from date, my from address, and my from date and to address. So by the time I'm really bad about planning out my travel in advance. If me and you are going to go to Minnesota for this weekend, I may have 2 weeks notice, and that's about it. I don't have time to do the change of address forms or the interstate travel forms. I just leave my SBRs at home. Does that make sense? But theoretically, if you knew you were going to go on a trip, you'd go ahead and get that filed in advance, and then you'd be okay. Okay. Now, there's a neat little trick on this point too, though. You can get travel forms for 365 days. And so what I mean by that is you can fill out the form and saying, I'm going to my house, to my mother-in-law in northern Minnesota, to her house. And my travel dates are 1/1 to 12/31. So no more than 365 days. And they will return to the original location. So now I've got a ticket for an entire year to take that specific thing covered by that change of address form from point A to point B and back for 365 days. And there's nothing wrong with having 7 of them. So if I'm a tournament shooter and I know that I'm going to be going to these 7 major tournaments every year, I go my house to that range over in, I don't know, what's a cool place to go? West Virginia?
Super cool.
Oh, okay. But I could have 7 different ones with these 12-month tickets. And so when these tournaments come up, I can travel back and forth all day long, right? And then I calendar it on month 11. I calendar it as a reminder to refile those same ones again. And so that way I can have a continuous permission to take my silencers to my house, to these places that I know I go to regularly. You follow that?
Yep, that makes sense.
That's
Going back to Derek's question, he was specifically talking about, the question is more along the lines of what is expected behavior for law enforcement agency to do with the Clio copy of the Form 4. For example,
yeah,
a recent sheriff I spoke with told me he keeps them on record at his office. Doesn't that create a gun registry, though?
Well, the funny thing about that, this was a requirement that they came up with in 2016 as part of this fingerprinting and photograph requirement. Up until that point, they required, for individuals, they required Clio sign off. And so you had to go to the sheriff and get him to approve that it's okay for you to have a silencer back then. And that was a problem. That's part of the thing that led to the creation of this cottage industry called gun trusts, because you could avoid all that with a gun trust. But so they eliminated the Clio approval process in 2016, and then they came up with what I call the Obama junk mail requirement, because they required you as part of a Form 4 application to send junk mail to the Clio of your choice, and bombard them with paperwork that they never wanted and never asked for and probably are never going to look for. So as far as I know, there's nothing wrong with throwing them in the trash as soon as you get them. There's nothing that says you have to keep them. And I think that a lot of them either just throw them in a box and they end up somewhere and nobody's keeping track of that. I have not heard of anybody digitizing and saving that for some future purpose, because it was never, it was just a junk mail requirement put off on all these Clios.
Right.
So I think you could legitimately run it through the shredder the second you receive it.
Good info there. Yeah, and as far as well, I won't even get into that when I talk about gun registries. There is a gun registry because I'm a gun registry essentially as a dealer. So we have to keep all of our background checks, and it covers everything on there. So while they don't keep them directly, they're basically contracting that out to us, subcontracting that out to us. So you can take that for what it's worth. Or at least that's my feeling on it. What else, folks? What other questions you got? We've covered a lot. It's already been an hour and a half. Yeah, it's been very enlightening. You know what, Greg? There you go. It's just regular basis. Well, technically, I think legally, being that it used to be the same state, it's not technically going across. Actually, I won't say that. That's not good legal advice. I see it like crazy down there. Gary, you must be indoors. Yes, I am. I am indoors. Serial number errors. Greg, you got to formulate questions a little bit better, buddy. With your, I'm assuming you're saying serial number errors on a trust. What happens with that?
I don't have any. The identity of a gun doesn't show up anywhere in any of my gun trust documents. So there are a lot of trusts out there that require something called a Schedule A, and a Schedule A is basically there's this paragraph in the front of the trust that says everything that's in this trust is listed on the attached Schedule A, and so all those trusts then require you to write the make, model, and serial numbers of all your firearms down and put that on the back page of the trust. So, but my trust, when a stranger is holding on to it, the only thing, there's no requirement that a trust have a Schedule A. When a stranger is holding on to my trust, the only thing that they could possibly detect is in it is $1 the day set up. So there's no way of having a serial number mismatch on my documents because they're not in the documents. And the serial number of an NFA item is on the actual tax stamp itself. So there's no reason for me to keep a list of things, because my tax stamp is the proof that that's a legal registered NFA item, and the government has already said that's correct. So maybe that's what he's saying, that maybe I wrote it wrong on my Schedule A, and that's a problem. That may be what he's asking for.
Maybe so. Mark, going back to, so I'm actually, it's actually essentially outdoors. I'm basically, it's all open under here. The weather's been very mild here. It gets a little warm during the day, but it's been like right now, it's basically, I don't know, maybe 70 degrees. Not bad. Let's see what we got here. Greg says the template would not accept the original SPR registration. I tried to correct and never had a response from the ATF.
When you make a mistake when you're filing a Form 1 application electronically, and you make a mistake, they basically just have you cancel the application and refile it, a brand new application. And they when it is not a successful application, they refund the $200. So a few months from now, you'll get a check or something in the mail with your original $200 tax payment back, but you will need to refile a brand new one. They're not going to let you just correct it on the fly. When you're filing electronically, they want it right the first time. So I think that's maybe what he's asking.
I think that's correct. Folks, we're going to answer these two last questions, and I know Jim's got a weekend to enjoy as well, and kind of getting busy up here too. So we'll hit up these last couple questions, and maybe we may need to have a follow-on a couple months down the road or something like that, and definitely have Jim Willi back. Talking about pistol braces, there's lots of questions going on with essentially they are trying to do a registry without a picture registry, as I understand it. Just your overall thoughts and legal advice on that, Jim.
So, pistol braces has always been kind of a gimmick. It looks like a stock, smells like a stock, but it's not a stock because it has a place for you to be able to stick your arm in and put some Velcro on it. Let's all pretend that that's how we like to shoot them.
It's freedom smuggling. That's what I call it.
What's that?
It's freedom smuggling. That's what I call it.
But I call it something more like a modified fleshlight, if you know what that is. But, it's got that nice, Anyway, but it's I've never liked those anyway, but not or fleshlights for that matter. But anyway, everybody knows that you just ignore everything. The ATF used to say, "Oh, you can't shoulder it because that converts it into a short barrel rifle," and then they reversed on that one and said, "Well, if we're saying that's not a stock, then it's not a stock, and so that it doesn't matter how you use it." So, they've sold like 7 million or more of these out in the of these AR pistols, right? So, that's bothered them. They've kind of gone down that trail. It's bothered them that they think they made a major mistake going down that route. And so they're
missing out. They're missing out on all the money that they would be getting from those tax stamps for SBR.
Money, right? I still believe that's true, that it's all about the money. But so anyway, they came out with this checklist system, and point-based system. Let me grab it. It's on my desk actually because I was trying to study this, trying to figure out what the hell are they doing. And to me, it's this long list where you go through. It's not in Spanish either. 2 pages of sitting there trying to analyze your gun to try to figure out if your device has this feature, so that you can then apply a point system. And this is 0 points, 1 or 2 points. Here's 3. But the bottom line is, if we have 4 points, then you're illegally in possession of a short barrel rifle. And it even includes things like if you've got optics on that pistol, AR pistol, then that adds points. And so just the fact of putting an optic onto that raises the risk that you may be, in fact, having an SBR under the new regime, right? It's a trap for everybody to catch the unwitting person at the range with something that they think is cool and they think is legal, but all of a sudden it's not. And everybody, they bought it legal, they did everything legal. Now all of a sudden they're at the range, and the ATF guy wants to arrest you for a felony because your thing has too many points. So I've been telling everybody for years, just file your Form 1 application if you've got any concerns whatsoever that might be a trap. Pay the $200, get your Form 1 tax stamp back. That way you don't have to worry about it. They can go pick on that other guy down at Bay 8.
Sure. I think we did kind of talk about this. Have you already discussed the naming of a trust? Sorry if I missed it.
No.
Go ahead, Jim, on that.
So back when I first started doing trust, they would make this. They would the dealers were selling gun trusts for the purpose of selling silencers, and so they were doing this traditional thing of, saying the Gary and Summer Melton revocable living trust. So you have this gigantic trust name, right? And that nobody cared, But the problem is when you build an SBR, or you build something. So basically, I'm saying Form 1, I'm a homemaker of things. You have to engrave the name of the trust and the city and state on there. So when it became obvious that if you're building SBRs, you want a short trust name, right? Because you have to, when you're building, you convert that AR pistol to a short barrel rifle, you have that additional requirement of engraving the name of the trust and the city and state on there. And the only thing you can abbreviate is the 2-letter mnemonic for the state, like TX or W or whatever. But you have to have your entire city name. And so if you live in East Creek Holler, that's all on there. It's so I'm a big fan of short trust name. All of mine, me, brother, dad, other brother, son, nephew, and dad, we all have the same exact trust name, Willi NFA Trust. And there's nothing wrong at all with having as many Willi NFA trusts as we want, right? But the fundamental idea is you want to keep it relatively short. Now, I am a big fan of putting the last name on there, and some people disagree with that. Okay, so why? Because if I ever get pulled over by the game warden or the police officer, and I pull out my tax stamp and it says Willi NFA Trust on there, and I show them my driver's license and it says Willi on there, they're done.
Right.
They've made the match. Or if my son, who more likely younger son out there, he could show he's a Willi, they're just going to assume everything's okay and go away.
That makes good sense.
A lot of people, yeah.
No, I was just going to say. So as far as if there's any advice that you would give, as far as naming a trust, keep it short. Use your last name so that it just clarifies things quicker.
I like that. But main thing to me is keep it short and keep it as bland and unrememberable as possible. You don't want to be the Second Amendment freedom fighters, liberty seekers trust, because they're going to go, oh, I remember that guy. I want to be forgotten.
Don't put whispered death as a trust for all your suppressors.
Or if you think you're the first one who came up with "In God We Trust," you're severely mistaken. So,
see, I wasn't even smart enough to think of that. That's the next trust I make. That's the one it's going to be.
I sometimes feel like calling them and saying, "Well done," because that was very clever. I see lots of trust names out there, but I want to be unrememberable. If it's Smith NFA Trust, they're never going to remember that. And there's a million Smith NFA trusts out there.
That's all.
But
Well, DG says this has been the most informative discussion I've heard in quite a while. Really glad I had a chance to watch most of it live.
He doesn't get out much.
He doesn't get out much. He doesn't get out much. The fact of the matter is, and that's why I thought it was so important to have you on. There's just so much misinformation or unclarified information or things that we think we know that we've never heard from an actual expert. It's just, it's the game of telephone when it comes to legal advice on Class 3 or NFA items. So I thought having you on would be.
In Gun Trust Guru, I try not to talk to the customers. I try not to talk legal advice because there's a fundamental thing going on here. Is Gun Trust Guru is strictly legal forms with no legal advice, and so we try to explain as best you can, but I don't like people to be calling and asking me how to set up their trust because that's when I kind of defer a lot of times. Like I can't really be providing you with legal advice, and you probably ought to get your trust from a attorney in your state. So I try to draw the line where I'm not providing legal advice, just the best forms that are based on a lot of thought out there. So it's an automated system and I very rarely actually talk to the customers.
Yeah. And again, folks, that's exactly what it's set up for. You'll go on his website, if not, even if you have a trust, go on his website right now and just start going through that process. You'll see that it's pretty self-explanatory. Again, I did it on my first try. I'm not very smart, so you guys will be able to do it too. So again, go ahead.
Yeah, I put some improvements in there a while back too, like a few months ago, where I put some things like, "Do you need help understanding this term?" The answer is yes. Read it, because that's the questions you're calling me up later and asking me. And if you just clicked on yes, you could have read the blurb that tells you everything I think you're trying to know. So
Sure.
I get a lot of people that say, no, I'm too proud to ask for help. And that's the ones that are calling me and saying, I think I fucked this up. And it's like, huh. And I can correct them if they do have a problem and they made a mistake. I don't care if it's their fault or my fault. It's you. But if they made a mistake, all they have to do is let me know, and I can edit from here and send them out a quick. I can get it to them as soon as I'm here. So
Sure.
Don't be scared that if I don't do it right, this very first time, that I'm going to punish them. Just let me know if you misspelled your wife's middle name. I can fix it and get it out to you in a couple minutes if I'm sitting here at my computer.
If I was you, I'd make them pay for the whole thing all over again, Jim. I think stupid should hurt.
As crazy as this sounds, a lot of this is not about. A lot of it's about the money, but it's not all about the money. I mean, I have fun getting to be able to talk to people all over the country that are interested in the same kind of things that I'm interested in.
And folks, that goes back to somebody earlier said about the content on our channel. I only do things that I'm genuinely interested in myself. And that goes to products, goes to training videos, it goes to discussions like this. Not once do I think about, is this going to be a popular thing? I do stuff that I like. I carry products that I like. If it resonates with people, that's great. If it doesn't, well, you know what? I had a good time. So that's what it's all about. But anyways, I appreciate that there are other people that clearly share some of the same interests as me, and those are the types of people that I want to surround myself with, and not necessarily just trying to placate to the masses. That's not what I'm here to do. Folks, we're going to cut it off right there so that Jim can get out there and have a good weekend. Jim, listen, man, I really enjoyed talking to you. I really appreciate you taking all the time and being so thoughtful with your answers. And we'll definitely have you on again. Folks, again, one of the things that I haven't really talked about on this is that, we started referring, and this goes back to his character, right? And maybe it's just a good business model too. But the fact is that we started referring people to Jim through our business, and then next thing you know, he was sending us, a little thank you check, right, from every purchase. Just and folks, it's not a lot, but again, it's just more of a token of appreciation to us. So we really appreciate that. So with that being, go ahead.
That said, there's a place on there that says, "Who can I thank for the referral?" Make sure you say Paramount Tactical. So I know it's Gary gets the reward for all his hard work.
Yeah, so we appreciate that, but you know what? If you don't, we're happy to push Jim all the business in the world, because again, he does a good job with that. The website's great, self-explanatory, makes it simple. Make sure as much as he can within the construct of what a gun trust is, cover you for all your basic needs with that. And again, it's very specific, it's state specific, all of those things. So again, we really appreciate your time. We appreciate what you do, Jim. We're definitely going to have you back on here. We'll look at maybe a couple months down the road or something like that. Looks like, I think we're going to expect to see a lot of new changes on the ATF. And like I told you earlier, you ever plan on doing your own YouTube stuff, we'd be happy to help you out with that, because I think you'd have a huge audience right away. I think people would really appreciate that. So folks, we're going to call it a night. Go to guntrustguru.com. If you don't have one, make sure you get a new gun trust. If you do have one, it's probably garbage. So get one from Gun Trust Guru, and just stick it inside there and use it. Make sure that you're covered. And if you don't even have any guns, go get a Gun Trust Guru Trust just to support Jim. So again, we really appreciate you. Appreciate all the time you gave to us tonight, and have a great weekend, Jim. And everybody else, make sure you guys stay armed, stay ready, and we'll talk to you soon.